Next case to come before us this morning is Omobien versus Flinn. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any time, please let me know when you get started. Please don't use the names of any minors or victims. I don't believe we have that problem here, but we are live streaming and this will be recorded and posted on the YouTube channel. So we try to make that advisement on every argument. We have read the briefs and we are ready to proceed when you are.
Good morning, Your Honors. My name is Attorney Connie Hightower and I represent the appellates Eddie Omobien and Linda Omobien, appellants, and I would like to reserve 5 minutes for rebuttal, please. A brief statement of the facts. This case involves a motor vehicle accident from March 11th of 2016, and this personal injury case was first commenced in Summit County in case number 2018-03-1102. After the defendant was served and failed to answer, there was a pending motion for default judgment, and at that point in time, then counsel for the defendant had raised a lack of service issue. Judge Sinclair in that case had determined that there was a lack of service issue, although the defendant had not appeared nor had given an affidavit. Consequently, the case was dismissed for other than on its merits and without prejudice on May 8th of 2019. Under the saving statute contained in 2305.19A, that would mean that the case could be refiled within 1 year. The counsels on the case were the same. I was the appellant counsel or the plaintiff counsel, and defendant's counsel is the same as the appellee's counsel is today and is the same on the refiled case. That case was refiled on March 8th of 2020. Of May 8th of 2020, and that was within the applicable statutory period to save the statute under 2305.19A, pursuant to the saving statute. That was also in the middle of the national pandemic. And despite that, however, on June 8th, defendant filed a motion to dismiss, stating that the case was time barred. And again, as I stated, the reason that I'm referencing the national pandemic is, of course, because there was House Bill 197 as well as the Ohio Supreme Court actions, which addressed statute of limitations and tolling of filings under the civil rules during the national pandemic. We bring to this court today 3 assignments of error. The first assignment of error is based on the trial court erring as a matter of law, abusing its discretion, violating the due process rights when it dismissed the case with prejudice. The second one addresses that a responsive pleading motion to dismiss based on lack of statute of limitations on a savings clause should not be pled in a responsive pleading, as well as the COVID-19 pandemic restrictions. I understand that this court will review this case de novo, as it is a motion to dismiss, and we ask the court under the first assignment of error to consider what is contained in 2305.19A as the saving statute, and that this particular complaint was filed pursuant to the saving statute and pursuant to the civil rules. The case that has been brought before the court, which is Peterson versus Teodosio, is not contained anywhere in Ohio law in terms of, statutory law or civil rules. It's only case law. That being said, it has been clear with the legislative intent that they would like people to be able to handle their cases based on its merits, and that's what should occur in this case. Also, Peterson versus Teodosio is distinguished by the Boggs v. Landmark case, where it distinguishes a refiled case from cases addressed in Peterson if the defendant has knowledge that the refiled case was within the saving statute. And also, in that case, they found that the dismissal was not warranted, as the defendant was aware that the case was not time barred pursuant to the saving statute, and despite their filing. In this case, the case was not time barred, and it should be allowed to proceed on its merit. I'm sorry. Oh. In the responsive pleadings, Civil Rule 12B allows a case to be filed to ask for the court to dismiss the case based on its complaint. The issue, though, is written in Civil Rule 12B, there is no mechanism for dismissing for the statute of limitations because on the statute of limitations, there may be some ancillary evidence that may help the court to understand why the saving statute was employed and whether or not the case was actually was time barred. In this specific case, the defendant filed the responsive plea or the Civil Rule 12B prior to filing a responsive pleading, and we're asking the court to find that it is barred. We're asking the court to reverse based on that reason. Also, in terms of the pandemic, there being a pandemic under House Bill 97, there were certain things that were told and certain findings that were made by the governor of the state of Ohio. Supreme Court followed suit in its March 27th administrative actions, which allowed cases to be told in terms of filings as well as the civil rules through July 30th of 2020. When we look at the facts in this case, not only did the defendant file a motion to dismiss during the pandemic, it was also, the response periods were also contained within the administrative action deadline, or where it had at least been told by the Supreme Court, as well as what had been passed by the governor. As indicated in the brief, there's reasons that those were filed in addition to who was considered essential workers, staffing issues. Lawyers were also affected, the ability to be able to work through email, find things that were being emailed, having staff with daycare issues, attorneys with daycare issues. There was all kinds of things in addition to people getting sick during the national pandemic. I would ask the court to consider these assignments of errors here to allow this case to be reversed so that it may proceed on its merits based on the notice and opportunity to be heard. We believe that all of that has been provided to the defendant in this case, and we hope that this court would find that the trial court's order should be reversed. Sorry. Thank you.
Thank you, counsel. You'll have a full 5 minutes for rebuttal. Ms. Hayes?
Good morning, Your Honors. Allison Hayes here on behalf of appellee Sharon Flinn. The issue here, Your Honors, is not whether the Omobiens could have relied upon the saving statute. The issue here is that the Omobiens never raised that in the trial court. They never asserted any exception to the 2-year statute of limitation imposed by Ohio Revised Code 2305.10A. They simply filed a complaint in May of 2020 with a different judge than the initial case, with allegations of negligence resulting from a motor vehicle accident, which occurred more than 4 years earlier in March of 2016. When plaintiffs refiled their complaint on May 8th of 2020, myself on behalf of defendant Flynn filed a motion to dismiss on June 8th of 2020, and the Omobiens counsel did not file any opposition to the motion to dismiss. So the trial court warned the Omobiens attorney that they would have until July 13th of 2020 to file an opposition within 14 days of that order, or the case would be dismissed with prejudice. But the Omobiens did nothing. They did not request leave for additional time. They were utterly unresponsive, which has been the case for the duration of this lawsuit. Not following the court's order to file an opposition to the motion to dismiss within 14 days, the court finally dismissed the case more than a month later on August 19th of 2020, which was 72 days after the motion to dismiss was filed and 103 days after the refiled complaint was filed. At any point in time in those 72 days, the Omobiens could have done any number of things. They could have filed a response. They could have asked the court for more time. They could have made all of these arguments about the saving statute. They could have amended their complaint to conform with the statute of limitations, but they did nothing. And it's important to keep in mind that the Omobiens also did nothing in the initial filing. This case was originally filed in March of 2018, and for 9 months, they never sought to successfully serve defendant Flinn. And that's important because opposing counsel has argued that, you know, the same attorneys were involved. Well, Ms. Flinn has never been served at any point in time throughout either of these lawsuits. There's no indication in the record whatsoever that she has any idea that this lawsuit is even pending. So in the initial case, the trial court ordered plaintiffs to take action to show good cause as to why Ms. Flinn had not been served, and they did nothing. So after a year of inaction and after over a year of unsuccessful service, Judge Sinclair dismissed plaintiff's original complaint in May of 2019 for failing to perfect service within 1 year. And then plaintiffs had, yes.
Can you hear me? Okay. Regarding that first case, and I want to make sure I have this right, or maybe I misunderstood something opposing counsel said. Was there at some point a default filed?
The default was filed. I do believe it's after a motion to quash was filed in the initial case, because there was a service at a improper address and the certified mail was not signed for by Ms. Flinn. So I brought that issue to the court's attention, showing that the certified mail was not to the proper address and it was not signed for by Ms. Flinn.
All right.
And the
So
trial court,
you brought that to the court's attention, quite frankly, representing defendant in this case.
correct, Your Honor.
All right. I just want to make sure I had that. Go ahead.
Right. And again, the trial court agreed at that time, saying, okay, the defendant had not been served. The evidence is in the record, and ordered plaintiff then to properly serve the defendant. And there was no further attempts made on service at any point in time for the duration of those additional 9 months, at which point in time Judge Sinclair did dismiss the case. So in plaintiff's counsel referenced the Boggs case that she relied upon in her briefing, and that case is distinguishable here because the saving statute was never relied upon in this case in the trial court, because the appellants did not oppose the motion to dismiss. The saving statute was never raised at all in the trial court. Had the appellants opposed the motion to dismiss, they could have relied upon or argued the saving statute. They could have requested leave to amend their complaint, but they never requested the leave. They never did anything. And like I said, there's no evidence in this case that defendant Flinn had ever been served. Plaintiff's counsel is trying to impute knowledge of this lawsuit through her attorney hired by her insurance company. And there's no evidence that she had been served. Whereas in the Boggs case, it's indisputable that the defendant in that case had been served in the previous lawsuit, and they had undergone litigation before it was voluntarily dismissed the first time.
Counsel, I have a quick question. Isn't there a case law in this district that a defense like statute of limitations is not properly raised on a motion to dismiss? It's something that should be asserted in a responsive pleading instead.
Well, Your Honor, a motion to dismiss is actually a responsive pleading, and there's a ruling out of the 8th District that is incredibly unambiguous and quite persuading, and I quote, "Courts have consistently held that a motion to dismiss pursuant to Civil Rule 12b-6 is appropriate when the plaintiff failed to state in the complaint that the case had been previously dismissed without prejudice in the saving statute used." And that case is Kennedy versus Heckard, 2002 case out of the 8th District. Again, and I want to address plaintiff's counsel's reliance upon, yeah.
Can I go back to the issue, the kind of imputed knowledge issue? So, you know, you can read between the lines, but you just said it. Counsel is hired by the insurance company pursuant to the contract, but that you still defendant's counsel, correct?
Correct, Your Honor. Yes, I am defendant's counsel. But regardless of whether or not there's knowledge of a lawsuit, it doesn't dispense of appellant's requirement to plead facts in the complaint within the four corners of the complaint, which would enable a case to proceed on the merits. And failing to allege any exception to a statute of limitations, simply referencing a motor vehicle accident which occurred 4 years earlier, does not, in the four corners of the complaint, address any ability to proceed. It's the duty of the pleader, pursuant to the Ohio Supreme Court's rulings, it's the duty of the pleader to assert exceptions to the statute of limitations. Failing to do so can result in a motion to dismiss pursuant to 12b-6. So as I was saying, regarding the tolling issues addressed by House Bill 197, the tolling, the House bill did not address any time by which a party would have to respond to a motion to dismiss. And that is the issue here, that the appellants never responded to a motion to dismiss. They never took the time to argue any of these exceptions to a statute of limitations within the trial court. And there had been abundance of time, and over and over again, and repeatedly, the court had granted them more time, and it was never argued at the trial court. We never discussed the saving statute at the trial court level. This issue is now being raised for the first time on appeal. So with all of these reasons, appellees would respectfully request that this court uphold the trial court's order and dismiss plaintiff's complaint with prejudice.
Thank you, counsel. Ms. Hightower, you have your full 5 minutes of rebuttal time remaining.
Thank you. A few things that I'd like to address. First, it's inaccurate when counsel indicates that the appellants or the plaintiffs in this case did nothing. The plaintiffs served a complaint, and they received notice that that complaint was properly served in the 2018 case. As a result of that complaint being properly served, a motion for default judgment was filed prior to the motion to quash. Motion for default judgment was filed because there had been proper service in that case. It was only after that that counsel for the plaintiff, also counsel for the appellee, filed a motion to, or filed a notice of appearance, and then began to file filings in the trial court indicating that service was not proper. There was no affidavit from the defendant. It was merely an affidavit from the insurance agent indicating that their records show that the address where the defendant was served was not the proper address. So there was service. There were things that were done in the case. And then it was once a default judgment motion was filed that the counsel only appeared, but didn't make any sort of limited notice of appearance. And it appeared that they were there on behalf of the defendant. And that was also pled by both parties, in which the plaintiffs had answered in that case. Also, on a few of the other issues, in Kennedy versus Heckert, which was filed, we believe that the Boggs case is still distinguishing. And we believe that the legislative and the statutory intent in this is to preserve saving statutes so that the complaints can be heard on their merits, rather than to use a case law, which when you look to file a complaint, you're looking to the rules to ensure that you follow those rules. Finally, it is very relevant. It's not just House Bill 197, it's also the administrative actions of the Supreme Court from the administrative actions of the Supreme Court from March 27th of 2020. That is where that we see that the Supreme Court was concerned with the ability to proceed with civil litigation, not just civil, criminal, certain types of litigation that had been initiated during the pandemic. This case was filed in May. The pandemic began in March. This case is completely enveloped within the administrative orders. The House Bill 197 was the catalyst and then the Supreme Court followed up with the administrative actions. Their concerns were the ability for people to receive notices from the court. Their concerns were also staffing. There was all types of issues that concerned the Supreme Court to issue this administrative order. And I believe that what occurred in this case, and as what was indicated in the brief, was that those things were not received by appellant's counsel until they received the notice in the mail to indicate that the motion, that the case had been dismissed. And that was when that was received. There's all kinds of effects of the pandemic. And we're asking the court to take notice that this case is a pandemic case enveloped within some of the actions of the Supreme Court to avoid things such as this happening. Again, we believe that the law in the state of Ohio favors a case to be heard on its merits. We know that this case was filed within the applicable statute of limitations pursuant to the savings clause. Counsel has not argued that it was not filed within the amount of time and is only arguing that it's time barred because counsel is saying it's not pled in the complaint. We believe there's case law supporting our position. We'd ask the court to reverse the trial court's decision, remand it so that the case can proceed on its merits. Thank you.
Thank you both for your presentations today. Court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.